Hi, I'm Daniel Findling with Findling Law and thedivorceguy.com. We're going to take a really deep dive into alimony in Michigan, all of the considerations, everything that you need to know. Let's get started. All right, so what is alimony? There are two kinds, periodic and alimony and gross. We're really going to be talking about periodic alimony in this seminar. And the reason being is that alimony and gross is really a type of property award. It's a modifiable lump sum property payment. I'm going to pay you $10,000 in a lump sum in lieu of this, and we call it alimony and gross for enforcement purposes. But when we're really talking about alimony or spousal support, that's going to be periodic or monthly payments paid for either a presumptive term or a definite term of years. And what's it for? It's to support your former spouse for his or her maintenance. Think of it like child support for a spouse, but rehabilitative in nature. When we point to the power, the statutory authority for alimony can be found in Michigan Compiled Laws 552.23, which says that the court can award spousal support paid to a party as the court considers just and reasonable after consideration of the ability of the parties to pay, their situation, and all other circumstances. These are really vague terms. What's actually meant by what's just and reasonable? Ability of the parties, situation of the parties, or other circumstances? Well, we looked at case law to answer these questions. The first key case we're going to look at is Berger versus Berger, and that talks about what the purpose of spousal support is. The court's going to try to balance the income of the parties so that no one will be impoverished. It must be based upon what's just and reasonable considering the circumstances of the case. Well, what does that mean, circumstances of the case? We get the goal. We don't want to leave a party impoverished. And from a public policy standpoint, we really don't want people turning to the state for public assistance. That's really the public policy consideration, but we're trying to balance the income and needs. There's a seminal case that helps us understand what the alimony factors are. There are 14 factors. The seminal case is Louts versus Louts. We look at the past relations and conduct of the parties. How have you behaved during the marriage? Who's at fault? How long have you been married? The longer the marriage, the more likely we may see spousal support exposure. The ability of the parties to work includes an unexercised ability to earn income. What property were you awarded? Are there income-producing assets that may offset wages? How old are you? The ability of the parties to pay spousal support, your present situation. We also look at the needs of the parties, the prior standard of living, the health of the parties, the contribution of the parties, fault, the effect of cohabitation, and then there's always a catch-all in Michigan law, general principles of equity. What's fair? What is fair? The key learning here is a court at trial must make a specific finding on all 14 factors, provided they're relevant, but they must make a finding in order to make a determination of alimony. This is the roadmap of what needs to be argued and needs to be discussed when addressing alimony in a divorce. So if we're really going to look at the major factors, we can break them down to, well, what are the parties' earnings? How old are you? What is the education of the parties? How long have they been married? And what are their needs? If you think about education, the age of the parties, that really goes to the income. What is their ability to earn income? Needs, which summarize like the prior standard of living. Now, the first four, these are objective factors. They can be measured. Lawyers like things that are objective because they're easy to measure. The needs of the party really requires an analysis of a budget. And oftentimes in a divorce, we'll have our clients prepare a budget to find out what their financial needs are so that when the parties are divorced, nobody is left impoverished. So there are additional cases that help us understand each of these sub-factors and louts. With regard to the past relations and conduct of the parties, Sparks says that it's relevant. With regard to fault, it's a factor. It should not be given disproportionate weight. However, it must be considered. Is a party at fault? Did the marriage break down, for example, because someone had an affair or was abusive or whatever that case may be? That is a factor that should be considered in every alimony case. And we're going to take a look at a few other cases, the needs of the parties. It's what the objective is, what McGee says, is that we don't want to leave somebody impoverished. The ability of the parties to work is clearly an important factor, as we just. So we've evaluated these 14 factors and we've come up with an award, but when does it end? Well, really, 4 times, 4 reasons. If a party dies, alimony ends. Typically, we like to secure alimony payments with life insurance if somebody dies. In most cases, alimony will terminate upon remarriage. However, it's not required. It has to be specifically provided for in the order in order for it to terminate. New facts or circumstances since the entry of the alimony order demonstrating the magic words sufficiently changed circumstances to modify alimony. Alimony is always modifiable unless the parties have agreed to waive modifiability, which we're going to talk about in a moment. But alimony will continue until circumstances have changed. Maybe you've had a loss of a job or an increase in your income so that you could ask that alimony be reduced or increased, as the case may be. Remarriage or cohabitation certainly would be a basis to modify if not written into the agreement. The idea being that if something changes that's significant since the entry of the last order, that's a basis to ask that alimony either stop in its entirety or be modified. Let's talk about a staple waiver next. Okay, we addressed the notion that alimony is always modifiable unless you reach an agreement to non-modifiable alimony award. And you have to be very careful because non-modifiable means non-modifiable even if circumstances change, even if you lose your job, even if your spouse remarries the day after the agreement. If you meet the requirements that the parties understand that they have a statutory right to modify alimony and that they agree to waive that statutory right, you can contract away. Now, when we enter into a non-modifiable award, you usually get something in return. You get a guaranteed payment, but then you may say, you know what, it's going to be for 5 years and non-modifiable at this amount, non-modifiable. You can lock in that amount by agreement only. However, it's important to note a judge can't do that. A judge can only award modifiable alimony, but that does not prevent parties from reaching an agreement, and we often do reach agreements because the cost-benefit analysis associated with each particular case may support doing so. So I'm often asked, is there an alimony formula? And the answer is no, there's not. You have to look at those 14 factors set forth in law. However, almost every judge, and mediator, and divorce attorney will have a copy of Craig Ross's guidelines. He looks at age, education, length of marriage, and income, and his computer program gives his subjective idea of what alimony should be. Now, judges can look at these alimony guidelines, but they still have to make a determination and a decision on each of the 14 factors. Judge Lombard, he's now passed, but he was a Wayne County staple. He had a rule of a third, 1/3 of the length of the marriage, 1/3 of the difference of the parties' incomes. That was his idea. Sometimes judges will think of a percentage of income. And Judge Young out of Oakland County used to, in long-term marriages, say, listen, you've been married for 35, 40 years, whatever the case may be, we're going to equalize your incomes moving forward, so alimony will equal 50% of the party's income. That was sort of her rule. Now, any judge that writes an opinion applying one of these rules are going to get overturned on appeal because Michigan law requires an examination of those 14 factors. However, that doesn't mean experience from a practitioner would know what a judge tends to do. When I was practicing before Judge Lombard, I knew that he liked to do the 1/3 rule. I knew when I was practicing before Judge Young, she liked or considered equalization in long-term marriages. So having an understanding and experience of what a judge may or may not do is also important. Now, prior to 2019, there were some important tax considerations that we took into account. Prior to 2019, when the payer of alimony paid alimony, it was tax deductible. And when the recipient of alimony received alimony, it was taxable as income. Now, any award of alimony that was entered prior to 2019 in January, this rule under IRC 71 and IRC 215 applies. However, after January of 2019, any new alimony award, even a modifiable existing award that was entered beforehand, we're talking about after-tax dollars. So when the payer is paying alimony, it's off his net or her net income, and the recipient is receiving alimony, it is non-taxable net income. So let's talk negotiation strategies. Clearly, you want to be able to argue all 14 factors, be prepared, be creative regarding specific arguments. However, creative lawyering, can also make a difference. We oftentimes will do a present value calculation. Let's say, for example, we determine that we're going to agree upon a non-modifiable award of, let's say in this example, $1,000 a month for 10 years, and that's $12,000 a year, $120,000 over the course of the year. Well, we'll discount it to account for inflation. We'll do a present value calculation, and let's say the value of that $120,000 over 10 years has a cash value now of $80,000. And we can say, you know what, we're going to pay you or trade an asset worth $80,000 in lieu of that stream of payments. And that's also discounting and prepayment. We can assume debt in lieu of alimony, award property in lieu of alimony. You need to be creative in both the determination of the alimony amount and the exposure, and then, even more importantly, sometimes, how are we going to structure that payment? Are we going to make that a monthly payment? Are we going to trade something for it? These are important considerations, and experience does matter in negotiating an appropriate award of alimony. The award, the 14 factors, and the structure. Daniel Findling with Findling Law on thedivorceguy.com. This has been our deep dive into alimony in Michigan. It's inevitable that you may have questions. I want to invite you to contact our office. I provided our contact number below. You can also reach us on our award-winning website at thedivorceguy.com. If you have questions, feel comfortable calling. Let it be our privilege to help.